Good afternoon. We are going to take a little bit of time, not a lot, but just a little bit, to go through some of the things that you might already know about evidence, refresh your recollection for some of the things that you may have known about evidence and forgotten, hopefully introduce some new things about evidence and exhibits, and again, hopefully add to your toolbox tools that you'll be able to use not only in mock trial competitions, but once you have matriculated through law school and are actually in the practice. With that, let's get started. Evidence. What's the best way to define evidence? Evidence is the thing that furnishes the truth. Now, there's some assumptions that have been made before I can make that statement. Assumption number one, we are in a system that is interested in finding the truth. Assumption number two, we have people who participate in our system who are zealous about ensuring that our system is about truth. And assumption number three, that we have participants who are interested in learning the best practices that help ensure that the goals of our system, our rules of law, and the goals of that rules of law, which is justice and equity, remain well-founded in finding the truth. Not my truth, not your truth, not their truth, but the truth. Two categories when it comes to evidence. Category number one, testimony. Category number two, exhibits. That's it. Our world exists 100% completely of either truth that comes from testimony or truth that comes from exhibits. Now, we have the two categories of exhibits, but we have three universal components of all evidence. In order for evidence to be introduced, it has to be relevant, it has to be admissible, it has to be authentic. I'll say it again. It has to be relevant, it has to be admissible, it has to be authentic. Whose job is it? It is the job of the attorney who is proffering the evidence, whether it's testimony or exhibits. It is the job of the attorney who is proffering the evidence to ensure that the evidence that is being proffered, testimony or exhibit, is relevant, admissible, and authentic. Universal components are broken down this way. Relevance, Federal Rule of Evidence 401. As we walk through sidebar, as we walk through this presentation, all of the references that I make to formal rules of evidence are going to come from the federal rules of evidence. Why? Because they're the federal rules. So what? Most of our jurisdictions, most of our states have adopted one way or another the FRE, the Federal Rules of Evidence. They've either adopted them by literally adopting them and just changing them by reference. Instead of the Federal Rules of Evidence, we might be using the Texas Rules of Evidence, but the Texas Rules of Evidence may match or mirror the federal rules. Same with Louisiana. Many of the numbers, the 401, many of the numbers, the 801, the 801D2, many of the numbers mirror. But for clarification, when I speak to relevance in a learning environment, I'm referring to the federal rules of evidence. So let's get back to relevance. Federal Rule 401. When you're in a hearing or a trial and you have an attorney who is in their case in chief conducting a direct examination and they ask the witness a question, what were you wearing on July the 4th, 2022? Opposing counsel jumps to their feet and blasts Objection, relevance. What is the objecting attorney saying? The objecting attorney is saying that there is no logical conclusion for the evidence that is being offered to a fact that is a part of the case at hand. There's no connection. So when you think about relevance in the form of proffering evidence, or when you think about relevance in terms of objecting to evidence being proffered, the question that you're asking yourself right before you fire is there a connection to that question? Is it a connection to that exhibit that is related to what this case is about? If there is no connection, it's objectionable. But slow down. Before you jump, make sure that it's not one of those situations where opposing counsel who's asking the questions, who's proffering the evidence, make sure that they're not just laying some background, or make sure that they're not laying some foundation. Because oftentimes when we accredit, that's the first part of a direct examination. All directs have 3 parts. Sure, everybody knows that. The first part is to accredit. When we are conducting our accrediting, a lot of times, many of the questions that we ask on direct examination during the accrediting of our witness really isn't relevant. Where did you go to school? When did you graduate from high school? Where did you go to undergrad? What did you study? What year did you graduate? Oftentimes, information has nothing to do with the merits of the case, but it is rapport building, and it's allowed. So again, while we're all ready to jump in front of that moving train to protect our record, meaning we're all ready to jump up and object when we feel that it is good faith, when we feel that it is appropriate, and when we feel strategically that is to our client's benefit. We don't want to jump the gun and unnecessarily interrupt, number one, if it's allowed, if it's appropriate, and number two, if it doesn't hurt us. That's a different lecture about objections and the strategy as to when to fire and when not to fire. Let's go to the second universal component of evidence. The first was Federal Rules 401, relevance. The second is Federal Rules 402, admissible. Relevant evidence is admissible unless any of the following provides that it's not. But 402 necessarily has to be read with 403. 403 says the probative value of the evidence must outweigh its prejudicial nature. Because if the probative value does not outweigh the prejudicial nature, you might argue admissibility of the evidence all day, and the judge may correctly keep that evidence out. So again, while 402 speaks directly to admissibility, in fact, the second part of 402 says irrelevant evidence is not admissible. I didn't add that to the slide. But while we are keeping with 402 definition of admissibility, we have to use admissibility as a term of art in connection with Federal Rules 403. First, there's relevance, then there's admissibility, then there's authenticity. Those are the 3 universal components of evidence. Whether it's testimony, whether exhibits, it has to be relevant, it has to be admissible, and it has to be authentic. How do we determine what authenticity is when it comes to evidence? We look at Federal Rules 901. Evidence is actually what it is purported to be, right? This apple is an apple because it's purporting to be an apple. In the case of real evidence, this is the apple that was part of the event that make up the merits of this case. Don't want to jump ahead, just wanted to add that. Where's your focus? Your focus right now is on Federal Rules 901 that defines authenticity. Who gets to make the decision about whether something is authentic or not? The preliminary decision of authenticity is for the judge. It's not for the attorney who's proffering it. It's not to be determined by the attorney who's opposing it. It is to be determined by the judicial officer that is preceding the proceedings. While we're with our three universal components, relevance, admissibility, authenticity, please take a look at Federal Rule 1002. That's Federal Rule 1002. This particular federal rule speaks directly to authenticity because the best evidence rule was the rule of obstacle, right? It was the rule of exclusion because from its beginning through a majority of its lifespan, the best evidence rule kept evidence out unless it was the original document or unless it was an, here's my air quotes, approved copy of the original document. That's how the best evidence rule began. Nowadays, it's mostly used to exclude testimony that is serving as a summary of a document or a summary of a conversation or a summary of, right? If it's serving as a summary of a document, opposing counsel objects to the proffering attorney and says, best evidence rule. We don't need that witness's testimony. We don't need to rely on the credibility of that witness in their summarization. Give us the doggone document, right? So the way that it's currently used is not the way that it started out being used, but is still used. So when it comes to authenticity, think about, is this the best evidence? And if it's not the best evidence, can I get the best evidence? Because if it's not the best evidence and I have the ability to access the best evidence, I may have a real difficult time trying to respond to a legitimately raised objection to best evidence, right? Basic information, 1, 2, 3. Relevance, admissibility, authenticity. When we talk about evidence, we're either talking about testimony or we're talking about everything else, exhibits, right? It's a very small world, but that world contained there within is huge. Let's move to foundations. Foundations. We have 3 universal required components of evidence: relevance, admissibility, authenticity. How does an attorney establish that a document is relevant or that testimony is relevant? How does an attorney who's trying to proffer the evidence establish that it's authentic? How does the attorney who's trying to proffer the evidence establish that it's admissible? Foundations. It's the foundations. We lay the foundations so that, number one, we are using our most efficient use of time. We are exercising our most efficient use of the court's time, of the attorney's time, of the client's time, of the jury's time. And so because we're being efficient, we're going to lay some foundations, and those foundations are going to be integral to our presentation or proffering of the evidence, right? Efficiency. Another reason why foundations are so very important is because it is supposed to keep the theater of warfare fair, right? You've walked into the theater of warfare, the art of war, the art of advocacy based in adversarial techniques, right? And with that being said, there still has to be some fundamental fairness. And that is what the foundations help us do. So let's talk about lay witnesses. We're not going to talk right now about expert witnesses. That's more something that we will address directly in class. And that's more something that we direct in class during more of the practicals. So let's work with the lay witness. More often than not, what we expect in a courtroom, in a formal setting, we are expecting that a lay witness be able to testify truthfully, obviously, from personal knowledge. What does personal knowledge mean? It means direct sensory perceptions. What does that mean? Sight, sound, touch, taste, smell, expressions about their own intentions, expression about their own emotions, reputations of others. Skirt, is that hearsay? Slow down. We'll get there, right? What do we expect lay witnesses to do? We expect them to testify, obviously, truthfully, based upon knowledge that they have. That knowledge can come from something that they've seen. That knowledge can come from something that they've heard. That knowledge can come from something that they've touched, right? These are direct sensory perceptions, or it can be their interpretations of their own stuff, right? Their interpretations of their intentions, their interpretations of their emotions, and yes, the reputation of others. Here's some things to consider as we talk about lay witness testimony: admissibility, authenticity, and relevance. Federal Rules 801 D1C, voice identification. I listen to the voicemail, and that's who they are. Great. How do I get that in to evidence? How do I get a witness to be able to testify in court under oath, play this voice recording, and say, do you recognize that voice? I do. How do you recognize that voice? Because I've heard it for the last 30 years of my life. Why have you heard it for the last 30 years of my life? Because that is the voice of my spouse. How do you know that that's the voice, right? So how do you get a witness to testify about voice identification? How do you do that? Got to lay the foundation. What does the foundation look like? The foundation looks like it's relevant. What is this conversation about? The foundation looks like it's admissible. The foundation looks like it's authentic. How do you know that it is what you say that it is, right? Federal Rules 406, habit and routine. Federal Rule 404B, character evidence. Character evidence doesn't come in. If I didn't learn anything from evidence, I learned that. No character evidence, right? But if you learn that, you also learn accept, right? Which is what's so beautiful about the law, and which is what so many people dislike about the law, right? What are the exceptions? Well, there's a list of them. Where do I find that list? Look at 404B, right? That list is going to talk about motive. That list is going to talk about opportunity. That list is going to talk about plan, right? So I might not be able to talk about past crimes to say that because they did these past crimes, they may have also done this crime, the one that is the merits of this case. But I may be able to use that past crime to give evidence to support something different. Okay. What about reputation for truthfulness? That's 405A. And here is the big ticket. What is the big ticket? Hearsay. Just saying it makes you quiver with excitement, right? Hearsay. If you hear someone saying something that you don't want to hear, you can put your fingers in your ears and close your eyes and just say, instead of saying la 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 la, you say hearsay, 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 hearsay. No, no, you can't really do that, but hearsay. An out of court statement being offered to prove the truth of the matter that the out of court statement is asserting. Out of court statement being offered to prove the truth of the matter that is being offered to assert. It is what it says that it is because you said that it was. Oh, no. Except one, for instances where it's not hearsay, right? What's an example of not hearsay? Party admission. 801D2. 801D2. Party admission. Before 2011, the federal rule said it is a statement against a party's, no, it prior to 2011, I believe the rule said that it was a party admission. Now the rule says that it is a statement against a party's interest. Whatever your objection is, if you're raising an 801D2 objection, it means the same thing, right? We call it different. They took out the admission and said a statement because, you know, in our profession, admission is a term of art that has a specific meaning. And the writers of the rules wanted to make sure that the terms weren't being interchangeably when terms shouldn't be used interchangeably. However, if you stand up and say objection, well, if the opposing attorney stands up and says objection, hearsay, you look at the court, not at opposing attorney ever. You look at the judge, you ask the judge's permission, may I respond? Right? It's good manners. May I respond? 9 times out of 10, the judge is going to say, of course, please do. There's only 2 responses to a hearsay objection. Response number 1, it's not hearsay. Response number 2, there's an exception, right? If, in fact, it is a statement against the opposing party's interest, you wouldn't say, or you might, especially if you're in a mock trial competition, you may very well say FRE 801D2, right? Because if you're in a competition, you're expected to be able to cite out the rules. If you're in trial, you probably have your rules of evidence with you. You probably have all of that stuff tabbed. And so before you make a mistake on the record and just start calling numbers, you might quickly flip to your chart or to your tab or to your reference sheet, and then express 801D2 clearly states and give the court the definition. But the point of all of what I've just said is it's not hearsay. What about present sense impression? 801D1, present sense impression. What does present sense impression allow a witness to do? It allows a witness to testify to their own previous statement, right, of what their present sense impression was then. So I get to testify live today under oath in court about what my impression was of this thing a month ago, 2 months ago, 3 months ago, 4 months ago. How do I lay the foundation, right? Before I can say, well, what was your sense when you saw it 2 years ago? I have to lay a foundation, right? Foundation, the declarant perceived an event, the declarant described the event, the description was given while the event occurred or immediately thereafter. That's 801D1. Well, what about 801D2? Oh, wait, hold on a second. I may have done, yeah. So I got the, perfect, 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 perfect. If you're watching, what I did was 80131 is present sense impression. I will fix that before I post it. The next one down should be 8032, which is excited utterance. Again, I'll fix it. I'll post it. What is an excited utterance? An excited utterance allows witnesses to testify to their own previous statement while made under the stress of excitement. Under the stress of excitement. How do I get that out of court statement in? Because that out of court statement is being offered to prove the truth of the matter asserted. I get it in by laying the foundation, right? The declarant perceived a startling event. The declarant made a statement concerning this startling event. The statement was made while the declarant was under the stress of the startling event. What is 8033? State of mind. This is one of the broadest hearsay exceptions. Why is this one of the broadest hearsay exceptions? It's one of the broadest hearsay exceptions because it allows the witness to testify to what their state of mind was then. Right? So it's at some point, it was my state of mind previous to me being on the stand right now. So it's an out of court statement. I want that in because I'm trying to prove the proof of the matter that I'm trying to assert, right? But I get it in through the exception 8033 because I can tell you now what my state of mind was as to motive, as to intent, as to plan, what my emotional state of mind was, what my physical state of mind was, if I'm feeling some pain, if I'm feeling some injury, what my bodily health was, what the state of mind was about my health, right? It's broad, it's huge, it covers a vast landscape. So you've got to be able to know if I'm trying to get this evidence in, how do I get it in? And you've got to understand if I want that evidence out, how do I keep it out? Right? Because there are times where you might raise an objection and say, objection, hearsay. And the proffering attorney is nervous. The proffering attorney is anxious. The proffering attorney forgets that there's an exception. The proffering attorney, God forbid, doesn't know that there's an exception, right? Whose job is it then? It's the proffering attorney's job to know, because I've planned for this during my case analysis. I anticipated that you were going to object to this, and I've already made a plan about how I'm going to get around it because I'm going to rely on this exception. So I was ready for you. That is our job as the lawyer, to anticipate those challenges and anticipate a remedy to those challenges. 8034, that is a state of medical treatment, right? You say things that, oh my gosh, I don't want to die. I think I'm going to die. I was shot when I burgled the house. Oh, wait a minute. Were you Mirandized? Oh, right. Think of all of the different ways you made the statement. Yeah, it was out of court, but I want the statement in because I want to prove what I'm trying to assert. And you made the statement. Well, technically, it's hearsay, maybe, if it's not a statement against my interest, right? And maybe it is hearsay, but is there an exception? It's our job. Now, we've talked about relevance, admissibility, authenticity. That's just evidence in general. We've talked about some of the hearsay sections and the importance of laying the foundation, right? So before we get to this exhibit list, because I want to get to the exhibit list, but before we get to the exhibit list, how does 403, let's go with, how does 403, how does 402, how does 901 actually look? How does it look when I'm 401, 402, 403, 901, trying to establish the relevance, the admissibility, the authenticity? Often looks like this, especially if you're getting to an exhibit. But if it's testimony in the beginning, it looks like, who are you? Please state your name. I get some background information. I want to start to build some rapport. I'm moving on from building the rapport, and I'm going to actually put this witness at the scene. How am I putting this witness? Why am I putting this witness at the scene? If that's what I'm going to do, right? Because I have to establish that the testimony that this witness is going to give is relevant, is relevant. There's some connection to what this witness is going to say and the merits of this case. If it's a lay witness, more often than not, I'm relying on their personal knowledge. So in order to establish that this witness is going to give me information based upon what they know, right? I have to establish that they were there. What's the relevance? What's the relevance? What's the relevance? So a lot of those preliminary questions are relevance. Stability, well, it's admissible unless it's not, right? Authenticity, 901. I want this witness to talk about the conversation. The conversation is relevant because it is the conversation that led to the event, right? How do I get the witness to identify the voice? Lay the foundation, right? Do you know what this is? I do. It's a voice. Who it is a voice of? It's a voice of this person. How do you know? Because of XYZ. Lay the foundation. Lay the foundation. Continually ask yourself as you are preparing, do I have the foundation to support? Do I have the foundation to support? Is the question that I'm going to ask connected to, right? Can I prove that the thing is what I say that the thing is? Or can I help support or establish that the thing is what the witness is going to say that the thing is? Now, when it comes to exhibits, there's generally 3 basic questions plus whatever's necessary. Okay. Now, I've posted some litany of exhibit foundations. It's posted on Canvas. It's posted in the tab Canvas page. It's posted on the trial ad Canvas page. If you are on a mock trial team that I'm working with, you have access to my trial ad Canvas page. I've posted the questions 1, 2, 3, 4, 5, 6. How do you ask the questions? The litany for the foundation. I posted it. But depending upon what the evidence is, right? Because depending upon what the evidence is, I'm going to have certain questions. I'm going to have certain foundations. A business record foundation is going to be different than a photograph foundation, which is going to be different from let's say from a model airplane that is never going to go back with the jury, right? So those foundational questions are different except for the first 3. Except for the first 3. Do you know what it is? This is you asking the witness. What is it? And how do you know? Because it's those 3 that establish the basis for relevance, admissibility, and authenticity. Okay. So let's go on to exhibits. Exhibits. Why do we use them? Because they're persuasive. We like them. We get tired of people talking all the time. We are so multi-focused in every second of every waking hour that it's hard to just lean in completely and listen to the words that are coming out of somebody's mouth, right? After about 2 seconds, we start looking at our phones, we start looking at our text messages, we start looking at our social media. We're wondering what our cat's doing. We're wondering what cute videos of rabbits have been posted. Right? Our minds are all over the place. Our minds are so multitasking that it's hard to expect people to listen to words and expect those words to do anything other than bore people, right? So persuasive. It's persuasive. We like it. We also do it not just because we like it as far as exhibits. We do it because we understand that we have a learning theory when it comes to especially adults, but when it comes to people in general. Information presented in multiple formats has a greater chance of being received by the listener, being digested by the listener, being incorporated by the listener, being effectively compelling to the listener, and being effectively persuasive to the listener. Learning theory says information presented in multiple formats. You hear me say it. Now you see something that supports it, right? Leans me in the direction of assessing that something is more credible than not. Yeah? Okay. In addition, when we're talking about trying to persuade triers of facts, we have different learning styles. And I think we have all of these. I think everybody has all of these, but I also think that we are individually uniquely wired to prefer one way or the other. That one way or the other is easier for us, is less challenging for us, is most effective for us. And that's where we lean, right? So if I'm auditory, I'm pretty good with listening to lectures and creating that visual picture in my mind. If I'm listening to conversations, I'm pretty good about being able to key in on certain things and being able to make a connection, right? If I'm auditory, then being able to, if I'm auditory, then listening is not going to be my strength, right? Same for visual, same for kinesthetic. You can move on from there. So I want to be able to persuade in all of the formats possible as effectively as possible, because I want to not only educate, inform, and compel. Ultimately, my job as the attorney in this advocate role is to persuade. So that's why I'm going to use exhibits, because exhibits give not only the witness, but also the trier of fact the opportunity to be engaged and vested in the information that's being presented. 3 types of exhibits: real, demonstrative, documentary. Real can't be created by the lawyer. Real is, it's just real. It is the thing that is the thing, right? Real was a participant or was actively engaged or involved in the thing that has resulted in the merits of this case. Demonstrative, something that the lawyer generated. Documentary, virtually all writings. Those are the 3 largest groups. Some people will break the group of demonstrative down from demonstrative to illustrative. Illustrative, again, is going to be more like models of airplanes, models of skeletons. Those things don't go back with the jury. But for the purpose of simplicity, for the purpose of knowing that I'm going to post this recording, for the purpose of knowing that this is just a beginning to all the rest of what it is we're about to do, I'm using the larger 3 categories: real, demonstrative, and documentary, right? When we talked about, let's talk about documents, and let's talk about hearsay, and let's talk about foundations, right? Again, these are your foundations before I ever get to the document, because the one thing about documentary evidence is, because most of it's written, right? Think about it. What's the problem? Most of it is going to be subject to a hearsay objection. Yeah. So especially when you're preparing to put on a case and you have a document, something documentary that you're trying to get in, you've got to be, number one, secure and sure about your hearsay exceptions. And if you are on the opposing end, you've got to be secure and ensure that you know how to get around these exceptions. 803 business records. I'm not going to read it for you. It's on the slide. It is in your evidence books. If you have the Modern Trial Advocacy book, which is the book that I use for my trial advocacy class, which is, I know Mawe is excellent. Mawe is a NITA legend. Mawe is one of my mentors, as is the authors of Modern Trial Advocacy, 6th edition, which is the book that I've adopted. That's Lubet and that's Lore. If you have any of those references, if you have any of those books, you can dive into this world as deep as you're willing to go. You don't need my PowerPoint to get you there. You just need to be able to understand what this stuff looks like when it's living and it's breathing, right? And not just what it looks like on paper. Recorded recollection, which is very different than refreshing recollection. Recorded recollection is 8035. 803, 8 through 9, public records. Do the police records come in? Wait, what? They don't. Why don't the police records come in? What rule says that the police records don't come in? Because all intents and purposes, right? Whatever is in the records are hearsay, and there might even be hearsay upon hearsay. That is the last of the slides. That brings us to the conclusion of this really brief kind of dust off the cobwebs, kind of dust off the dust, get us back, get us focused, get us ready. If you are in my trial advocacy class, I've asked you to read chapters 10 and chapter 11. Chapter 10 is objections. Chapter 11 is evidence and foundations. If you are one of the mock trial teams that I'm working with, you've already had this assignment probably for 2 weeks, 3 weeks, maybe even a month now. If you are in the TAB class on Saturdays, again, a lot of this information is posted. I've posted common objections. I've posted hearsay objections. I've posted, there's a plethora of information, right? Information is great. Knowing how to use the information is what we're working for. So make sure that you've at least gone over the information so that we can digest the information, so you have some working understanding of the information. And then when we get to the practice of it, whether it's a hypothetical file that I've given you, whether it's a exercise that I've given you, whether it's a ad lib that we do in class, with the basic understanding from having read what these rules are, how these rules work, what these rules were intended to do, the practice hopefully becomes more meaningful and allows you to become more strategic as you use these tools. Thank you so much for spending the last few minutes with me as we went over evidence and exhibits, and I look forward to the next time. Thank you.